The Supreme Court chamber fell silent as Justice Amy Coney Barrett leaned forward, her gaze fixed intently on former Florida Attorney General Pam Bondi at the podium below. What began as routine oral arguments in a critical constitutional case had suddenly transformed into an unexpected confrontation. Barrett, known for her measured judicial temperament, broke from her usual restraint. "Ms. Bondi," Barrett began, her voice carrying throughout the hushed courtroom, "your constitutional argument contradicts established precedent in at least 3 major decisions. Perhaps you should familiarize yourself with Harrington versus Davis before presenting such theories to this court." The dismissive tone drew subtle reactions from the other justices. Bondi, representing a coalition of states in this high-stakes federalism case, stood momentarily frozen as Barrett continued her surprisingly pointed critique. "Furthermore, your interpretation of Article 3 jurisdiction seems fundamentally flawed. I'm curious how you reconcile this position with your previous legal writings." What happened next stunned everyone in the chamber, including the usually unflappable Barrett. Within moments, Bondi responded with a legal counter-analysis so brilliant and meticulously researched that it not only silenced Barrett's criticism, but caused the justice to visibly reassess everything about the attorney standing before her. Before diving into this extraordinary legal showdown that has Washington's legal circles buzzing, don't forget to like this video and subscribe to our channel for more in-depth analysis of the high-stakes battles shaping America's legal landscape. Justice Amy Coney Barrett had risen to the nation's highest court through a combination of brilliant legal scholarship and steadfast conservative principles. Confirmed to the Supreme Court in October 2020, the former Notre Dame law professor and Seventh Circuit judge had quickly established herself as a formidable jurist with a strict textualist approach to constitutional interpretation. Known for her sharp questioning during oral arguments, Barrett had earned respect even from ideological opponents for her intellectual rigor and comprehensive legal knowledge. Pamela Bondi had built her reputation through a different path. As Florida's first female attorney general from 2011 to 2019, Bondi had earned recognition for her tough prosecutorial approach and political savvy rather than academic legal theory. After her tenure, she had transitioned between private practice and political consulting, occasionally arguing high-profile cases, but rarely before the Supreme Court. Her appointment as lead counsel in this consequential federalism case had raised eyebrows among legal observers who questioned whether she possessed the constitutional expertise necessary for such complex litigation. The case before the court, Federation of States versus Department of Commerce, carried enormous implications. At issue was whether recent federal regulations had unconstitutionally encroached on state sovereignty in taxation and land use matters. The outcome would potentially reshape the balance of power between states and the federal government for decades to come. For Barrett, the case represented an opportunity to advance her originalist judicial philosophy at a time when the court's conservative majority was increasingly willing to revisit long-standing precedents. She had studied federalism extensively throughout her academic career and viewed this case as potentially landmark Bondi, representing a coalition of 17 states challenging federal authority, approached the case with different motivations. Having witnessed firsthand as Attorney General how federal regulations could impact state governance, she brought practical experience that complemented her legal arguments. She had spent months preparing for this appearance, aware that skeptics doubted her readiness for Supreme Court litigation of this magnitude. The initial exchanges had proceeded conventionally until Barrett launched her unexpected challenge. Court observers immediately recognized this as a crucial moment that could determine not only the outcome of the case, but potentially Bondi's future standing in constitutional litigation. Barrett's willingness to directly challenge Bondi's legal reasoning so early in the argument signaled that the justice had identified what she perceived as fundamental weaknesses in the state's position. For Bondi, the stakes couldn't have been higher. A poor performance would not only damage the case but confirm critics who questioned her selection as lead counsel. Yet beneath her calm exterior, Bondi possessed resources that Barrett had clearly not anticipated, resources that were about to dramatically shift the dynamic in the nation's most powerful courtroom. "Thank you for that question, Justice Barrett," Bondi replied, her voice steady despite the pointed critique. Rather than appearing defensive, she calmly rearranged her notes at the podium. "I'm quite familiar with Harrington, and if you'll permit me, I'd like to explain why it actually supports rather than undermines our position." Barrett raised an eyebrow, her expression suggesting polite skepticism. "Please proceed." Harrington's central holding relied on a specific reading of the Commerce Clause that Chief Justice Reynolds explicitly limited to circumstances where federal regulatory interest demonstrably outweighs state sovereignty concerns. Bondi began, citing the exact language without referring to notes. What's often overlooked is Justice Kavanaugh's controlling concurrence, which established a three-part test for such circumstances. Barrett sat slightly straighter, her interest visibly piqued, as Bondi continued with remarkable precision. Applying that test to our current facts reveals a crucial distinction. The regulations at issue in Harrington survived scrutiny because they met all three prongs, particularly the third requirement that federal action be tailored to minimize unnecessary state administrative burdens. Bondi then smoothly transitioned to a lesser-known case. This limitation was further clarified in Westmoreland v. United States, where the court invalidated federal regulations that failed this tailoring requirement, even while acknowledging legitimate federal interests. Justice Sotomayor leaned forward. "Counsel, Westmoreland was a relatively obscure Tenth Circuit decision, not Supreme Court precedent." "That's correct, Justice Sotomayor," Bondi replied without hesitation. However, this court cited Westmoreland's reasoning approvingly in footnote 23 of Montgomery v. Louisiana, specifically when discussing the limits of federal regulatory authority in areas of traditional state prerogative. Barrett's expression shifted subtly, a mixture of surprise and reassessment. She hadn't expected this level of nuanced case knowledge from Bondi. "Furthermore," Bondi continued, gaining momentum, "I'd like to address Justice Barrett's concern about my Article 3 jurisdiction argument by directing the court's attention to an often overlooked passage in Justice Scalia's dissent in Williamson County. While his opinion didn't carry the day, his analysis of jurisdictional limits in federalism cases was subsequently adopted by this court in Nick v. Township of Scott, effectively overruling the majority position in Williamson County." Barrett interjected, her tone now genuinely curious rather than dismissive. "Are you suggesting that Nick's holding on property rights extends to the broader federalism context we're addressing today?" "Yes, Justice Barrett, but not through simple analogy," Bondi replied. She proceeded to outline a sophisticated legal theory connecting Nick's reasoning to the current case through a series of subsequent lower court decisions that had gradually expanded its application beyond the immediate property rights context. The dynamic in the courtroom had transformed. What began as an apparent attempt to expose weaknesses in Bondi's legal reasoning had evolved into a high-level constitutional dialogue between two formidable legal minds. Other justices began engaging more actively, with Justices Thomas and Kagan posing follow-up questions that Bondi addressed with equal precision and depth. When Justice Alito raised a potential conflict with the court's recent ruling in Texas v. Johnson, Bondi demonstrated remarkable recall by distinguishing the cases on grounds so specific that several justices could be seen checking the case materials to verify her assertions. "Ms. Bondi," Barrett said, returning to the exchange with a noticeably different tone, "your reading of these precedents is certainly creative. However, I'm concerned that accepting your interpretation would require us to significantly narrow our holding in Denison, which has stood for nearly a decade as a framework for federal-state regulatory boundaries." The question was sophisticated and technical, exactly the kind of constitutional complexity that many had doubted Bondi could navigate effectively. The courtroom tensed with anticipation of her response. "Justice Barrett, I have tremendous respect for the Denison framework," Bondi began thoughtfully. "However, I would suggest that applying Denison to the current facts doesn't require narrowing its holding, but rather recognizing its inherent limitations, limitations that Justice Gorsuch himself acknowledged when writing for the majority, she then quoted directly from Gorsuch's opinion. This framework establishes general principles for typical assertions of federal regulatory authority, while recognizing that unique circumstances may necessitate more nuanced analysis. Bondi paused briefly before delivering her most compelling argument yet. Our case presents precisely the kind of unique circumstance Justice Gorsuch anticipated, where federal regulations technically comply with Denison's formal requirements, while functionally eliminating state discretion in a manner the framework never intended to permit. The Chief Justice checked his watch and announced that Bondi's time was nearly expired. Rather than requesting an extension, a common practice in complex cases, Bondi efficiently summarized her remaining points with remarkable clarity, demonstrating complete command of her argument. As she prepared to yield the podium, Barrett posed one final question, a hypothetical scenario involving conflicting state and federal interests so intricate that law professors would later incorporate it into constitutional law exams. The courtroom collectively held its breath, assuming the complex hypothetical would finally expose the limits of Bondi's legal acuity. Instead, what followed would become one of the most discussed legal exchanges in recent Supreme Court history. "That's an excellent hypothetical, Justice Barrett," Bondi responded, not missing a beat. "It highlights precisely the constitutional tension at the heart of our case." Rather than offering a simplistic response, Bondi methodically deconstructed the hypothetical, identifying three distinct constitutional principles that would guide the analysis. With remarkable precision, she cited relevant precedents for each principle, including several that Barrett herself had authored during her tenure on the Seventh Circuit. In your 2018 opinion in Wisconsin Manufacturing Association v. EPA, Bondi noted, you wrote that when regulatory frameworks create irreconcilable obligations, courts must examine which sovereign possesses primary constitutional authority over the specific subject matter. That reasoning provides a valuable roadmap for your hypothetical. Barrett's expression reflected genuine surprise, not only at Bondi's familiarity with her lower court decisions, but at the sophisticated application of her own judicial philosophy to the current problem. Several court observers later remarked that this moment represented a turning point in Barrett's engagement with Bondi, a shift from skeptical questioning to intellectual respect. However, Bondi continued, "I believe your hypothetical actually strengthens our position when we consider an often overlooked concurrence by Justice Thomas in Department of Revenue v. McClintock." She proceeded to explain how Thomas had articulated a limiting principle to federal regulatory authority that applied perfectly to Barrett's hypothetical situation, and by extension, to the current case. The analysis was so precise and legally sound that several justices could be seen taking detailed notes. Justice Kagan, known for her incisive questioning, attempted to identify a potential weakness. "Ms. Bondi, your application of Justice Thomas's McClintock concurrence seems to overlook the subsequent limitations established in Friedman. How do you reconcile those positions?" Without hesitation, Bondi replied, "Justice Kagan, Friedman's limitations specifically addressed interstate commerce applications, not the core federalism principles at issue here. In fact, the majority in Friedman explicitly stated that its holding does not extend to cases where federal regulations effectively commandeer state administrative apparatus under the guise of regulatory coordination, which is precisely our argument today." The technical precision of this response visibly impressed even Kagan, who nodded slightly in acknowledgement. As Bondi continued her constitutional analysis, she demonstrated not just knowledge of case law, but a sophisticated understanding of the historical development of federalism jurisprudence. She traced the evolution of key doctrines through decades of decisions, identifying subtle shifts in the court's approach that many constitutional scholars had overlooked. Barrett, now fully engaged as an intellectual equal rather than a skeptical, Interrogator posed a follow-up question that revealed her own evolving thinking. Ms. Bondi, if we were to accept your framework, how would you suggest we articulate the limiting principle to prevent its misapplication in future cases? The question invited Bondi to participate in the actual judicial crafting of constitutional doctrine, a remarkable shift from Barrett's initial dismissive questioning. It represented the ultimate acknowledgement of Bondi's legal acumen. Justice Barrett, I would propose a three-part standard, Bondi replied, proceeding to outline a nuanced approach that balanced state sovereignty concerns with legitimate federal interests. The framework she articulated was so thorough and carefully constructed that it addressed potential objections before other justices could raise them. This standard, Bondi concluded, would preserve the core principles of our federalist system while providing lower courts with clear guidance for resolution of future conflicts. When the Chief Justice announced that Bondi's time had conclusively expired, an unusual moment occurred. Justice Barrett requested that Bondi be granted additional time to complete her analysis, a rare procedural courtesy that signaled the court's engagement with her arguments. As Bondi returned to her seat following her extended presentation, the gallery buzzed with whispered assessments of what they had witnessed. Constitutional scholars in attendance exchanged glances of amazement at the unexpected depth and sophistication of her arguments. Barrett, who had begun the session seemingly intent on exposing perceived weaknesses in Bondi's legal reasoning, now appeared deeply thoughtful, reviewing her notes with an expression that suggested genuine reconsideration of her initial assumptions. The justice who had attempted to highlight Bondi's supposed limitations had instead discovered a legal mind of remarkable capacity, one whose arguments would need to be addressed with the utmost seriousness in the court's deliberations. The Solicitor General, representing the federal government's position against Bondi's clients, could be seen hastily revising his planned remarks, clearly recognizing that the constitutional battle had just become significantly more challenging than anticipated. The impact of Bondi's exceptional performance before the Supreme Court reverberated far beyond the marble columns of the courtroom. Within hours, legal blogs and constitutional law forums were dissecting every aspect of the exchange between Barrett and Bondi, with legal scholars expressing astonishment at the depth and nuance of Bondi's arguments. SCOTUS blog, the leading Supreme Court analysis site, posted an unprecedented mid-argument analysis titled Bondi's Tour de Force Reshapes Federalism Debate, noting that what began as routine questioning transformed into one of the most sophisticated constitutional dialogues witnessed at the court in recent terms. Constitutional law professors across ideological lines found themselves in rare agreement about the exceptional nature of what had transpired. A prominent liberal legal scholar tweeted, "Regardless of where you stand on the federalism question, Bondi's command of precedent and constitutional theory today was masterful. Law schools will be teaching this argument for years." Inside the Supreme Court's conference room, the private deliberations among the justices reflected the shifted dynamics. Sources close to the court later revealed that Barrett, in an unusual move, directly addressed her initial misjudgment of Bondi's capabilities. "I believe we witnessed an extraordinary display of constitutional advocacy today," Barrett reportedly told her colleagues. Ms. Bondi's analysis of the federalism precedents requires serious consideration, particularly her framework for balancing state and federal interests. The case, initially expected to result in a clear victory for the federal government's position, suddenly appeared much more competitive. Justices who had been inclined to dismiss the state's arguments found themselves grappling with Bondi's meticulously constructed legal theory. Media coverage extended beyond legal circles to mainstream news outlets, many of which focused on the personal dynamic between Barrett and Bondi. Supreme surprise, Barrett meets her match in Bondi Showdown, read one headline, while cable news panels debated the significance of the exchange for women in the legal profession. Bondi herself maintained a dignified public silence about the argument, declining interview requests and issuing only a brief statement. It was an honor to present these important constitutional issues to the court. The justices' engaged questioning demonstrates the significance of the federalism principles at stake. Barrett, known for her strict avoidance of public commentary on cases, similarly made no public statements. However, during a previously scheduled speech at a judicial conference 2 weeks later, she made a thinly veiled reference to the experience. The bench constantly reminds us that legal brilliance can emerge from unexpected sources and that intellectual humility serves justice better than assumption. The impact on Bondi's career was immediate and transformative. Law firms that had previously overlooked her constitutional expertise now actively sought her involvement in their Supreme Court practices. Leading law schools extended visiting scholar invitations, eager to have their students learn from her approach to constitutional advocacy. More consequentially, the case itself took an unexpected turn. When the court's opinion was finally issued 3 months later, the states prevailed in a 6-3 decision that adopted significant portions of Bondi's proposed framework for analyzing federalism conflicts. The majority opinion, authored by Justice Gorsuch, cited specific arguments Bondi had presented during oral argument, an unusual acknowledgement of an advocate's direct influence on constitutional doctrine. Even more remarkably, Justice Barrett wrote a concurring opinion that explicitly engaged with Bondi's analysis of Barrett's own prior decisions, acknowledging the persuasive application of those principles to the current case. Legal observers noted that such direct acknowledgement of an advocate's impact on a justice's thinking was exceedingly rare. The decision established a new 3-part test for evaluating federal regulations that impact traditional state functions, AHA, test that closely resembled the framework Bondi had articulated in response to Barrett's challenging hypothetical. Constitutional law professors immediately dubbed it the Bondi test, ensuring that her contribution to federalism jurisprudence would be studied by generations of law students. Beyond the specific case outcome, the Barrett-Bondi exchange entered legal lore as a powerful reminder about the dangers of underestimating adversaries based on background or reputation. Law school professors began using recordings of the argument in advocacy courses, highlighting both Bondi's exceptional preparation and Barrett's willingness to reconsider her initial assessment, both qualities essential to genuine legal discourse. 6. Months after the decision, Bondi and Barrett appeared together at a Federalist Society event, discussing the evolution of federalism jurisprudence. While both maintained appropriate professional boundaries regarding the specific case, their respectful intellectual engagement demonstrated how their courtroom encounter had evolved into mutual professional respect. During the panel discussion, Barrett made a comment that many interpreted as reflecting on their initial exchange. The most valuable moments in constitutional development often come when our assumptions are challenged by advocates who approach legal problems from different perspectives and experiences. Bondi responded with equal thoughtfulness. The strength of our legal system depends on rigorous testing of ideas, regardless of their source. When justices and advocates engage in good faith on the merits, constitutional principles are refined and clarified. For court observers, the lasting significance of the Barrett-Bondi encounter transcended the specific case outcome. It served as a powerful reminder that in the highest realms of legal thinking, intellectual honesty, including the willingness to recognize brilliance regardless of preconceptions, remains essential to the advancement of constitutional understanding. In legal circles, the phrase "pulling a Bondi" entered the lexicon, referring to moments when an underestimated advocate reveals unexpected depths of legal brilliance. Meanwhile, Barrett's willingness to reconsider her initial assessment enhanced her reputation for intellectual integrity, demonstrating that true judicial temperament includes the capacity to adjust one's thinking when presented with persuasive reasoning. The encounter between Barrett and Bondi ultimately reinforced a fundamental truth about constitutional advocacy: that the most significant legal advances often emerge not from confirmation of existing assumptions, but from their thoughtful and rigorous reconsideration. Thank you for watching our detailed analysis of this remarkable Supreme Court confrontation. If you found this breakdown informative, Please like this video and subscribe to our channel for more in-depth coverage of the constitutional battles that shape our nation's future. Hit the notification bell to stay updated on our latest videos, examining the critical legal developments that rarely receive the attention they deserve.